Reimbursement of business expenses under California Labor Code Section 2802. Making sure employers don't make their employees pay the company's bills.
Hello and welcome. I'm Roger Haig from Gateway Pacific Law Group, your ally in navigating employment law in California. Today, my friend Jarvis and I are discussing a crucial piece of legislation for every employee and employer in the Golden State, Labor Code Section 2802. Originally enacted in 1932, this law ensures that employees are not out of pocket for expenses incurred in doing their job. That's right. As early as the 1930s, California was protecting workers from having to shoulder the financial burden of performing their job duties. How about that, Florida and Texas? Let's dive into the why, what, and how of ensuring you're not paying to work for your employer.
Let's break down the law and see what it does. California Labor Code Section 2802 states in part that employers must reimburse employees for all necessary expenditures or losses incurred by the employee in direct consequence of the discharge of his or her duties. Before this law, employees often had to swallow these costs or fight long and expensive legal battles that usually cost more than the costs the employer forced the employee to pay.
Now, thanks to Labor Code Section 2802, employees can get reimbursed for a variety of work-related expenses. Examples include mileage driven for business purposes, using the IRS standard mileage rate, meals purchased while traveling for work, cell phone usage for work calls or texts, office supplies purchased for work purposes, with receipts, tools or equipment required for the job, with prior approval if necessary.
Before this law, employees had limited recourse for seeking reimbursement. So, often, employees had to rely on the goodwill of their employers, or they just had to face the dilemma of bearing the company's costs themselves.
If you incur a work-related cost, document the expense, retain receipts, and submit a detailed report to your employer. Should your employer refuse reimbursement, California law is on your side.
In cases of non-compliance, employees can recover the actual expenses they paid out of pocket plus interest on those expenses, and possibly attorney's fees. It's essential to consult with a legal professional to navigate these situations effectively. Also, when it rains, it pours. Failure to reimburse can also lead to violations of other labor codes, such as 226 for itemized wage statements, and possibly violations of Labor Code Sections 202 and 203 for timely wage payments. Each violation adds layers of liability for employers and can be expensive if it has been a company-wide practice for a significant period of time.
Additionally, California's Private Attorney General Act, or PAGA, allows employees to sue for civil penalties on behalf of themselves and other affected workers, which can overlap with Labor Code Section 2802 violations.
Each violation adds layers of liability for employers and can be expensive if it has been a company-wide practice for a significant period of time. Employers can't force employees to waive their right to reimbursement of the company's necessary business costs and expenses. However, some companies still try to do that. These so-called waivers sometimes get included in the numerous documents in onboarding packages. So, read all your onboarding documents carefully. Even though the waiver is probably not enforceable, if you see this document, it should raise concerns about the type of employer you're about to work for.
To sum up, Labor Code Section 2802 is a vital protection for employees, ensuring you're not shouldering the business costs of your employer. The reason why California Labor Code Section 2802 was passed was to prevent employers from passing their operating expenses onto their employees, ensuring a fair and equitable workplace. From mileage to mobile phone bills, if the cost is necessary so that the company can make a profit, your employer should cover it. So, if you're facing challenges in getting reimbursed, or if you're an employer seeking to navigate these laws, we're here to help.
If you have questions about expense reimbursement or believe your employer is violating your rights, contact Gateway Pacific Law Group for a free consultation. GPAC Law is experienced in employment law and is here to help. Don't hesitate to call GPAC Law at 562-485-6151 or visit GPAC Law's website and social media accounts at www.gpaclaw.com/GPAC-la to schedule a consultation today. Thanks for watching.